Okay, we're good. We're live. Hello, everyone. Good afternoon, dear temporary foreign workers. Welcome to this session. The Government of Canada Temporary Foreign Worker Program has provided $2.18 million of funding to CAOs to support and help empower temporary foreign workers, primarily in the agricultural sector, during the COVID-19 pandemic and concluding in December 2021. CAOs used the Government of Canada funding to expand their support and service to temporary foreign agricultural workers by partnering with organizations in the Atlantic provinces and in Ontario. In Ontario, for example, CAOs partnered with CARE for International Workers that is sponsored by Windsor-Essex Bilingual Legal Clinic to develop this project. CARE is formed of 8 agencies: the Consulate of Mexico in Leamington, Windsor-Essex Bilingual Legal Clinic, Occupational Health Clinic for Ontario Workers, Windsor-Essex Compassionate Care Community, the Meta Collective, Meditation and Wellness Support, the Templo La Buena Semilla, the Neighborhood Organization, and Windsor-Essex Community Health Center. CARE will participate in 6 of the 8 partners to develop this project. Today, one of the partners, which is Windsor-Essex Bilingual Legal Clinic, is going to provide you with information about housing standards, inspection requirements, and non-compliance with COVID-19 protective measures. Our speaker has been working with the Windsor-Essex Bilingual Clinic for 13 years as a community legal worker. She speaks Spanish, has a law degree and master's degree in administrative law for her home in Colombia, studied the paralegal and the language interpreter program in St. Clair College, and is currently a candidate awaiting to call to Bar of Ontario. Since January 2017, she has successfully led the CARE for International Workers program and the Spanish-speaking clients program at the legal clinic in Windsor-Essex County. Francie is a high-profile advocate for international worker safety, education, and wellness in Windsor-Essex. She regularly collaborates with various social services, health, governments, and settlement organizations to develop, implement programs, and support international workers. She is the project manager in the CARES We Care project and aims to provide emergency support and services to TFW, or temporary foreign workers, in the Windsor-Essex region during the COVID-19. Ladies and gentlemen, please welcome Francie Munoz.
Thank you so much. Okay, we are going to start. Next slide, thank you. Okay, today we are going to talk about the Open Work Permit for temporary foreign workers. This is a special program that the government launched in 2019. So we are going to start. This presentation, the disclaimer. This presentation doesn't replace the Immigration and Refugee Protection and its regulations and should not be used as a legal advice. It's for general information only. No solicitor-client relationship arises as a result of accessing to this presentation. For information and advice particular to your situation, you should seek legal advice from an experienced lawyer in your jurisdiction. Temporary Foreign Workers Program. The government has the Temporary Foreign Workers Program for temporary foreign workers. They are foreign workers hired through the Temporary Foreign Worker Program to work in Canada for a limited period with a valid work permit. So Canadians employers can hire temporary foreign workers under 4 streams. The Seasonal Agricultural Worker Program is also called the SOAP program. Is for 8 months. The agricultural stream is for 2 years. The stream for low-wage positions and the stream for high-wage positions. These are the programs that the government has created to let employers to hire temporary foreign workers in Canada. Thank you. So we are going to talk about the two first programs, are the most principal programs that we have here in Ontario. We have the workers that are coming to Canada under the Seasonal Agricultural Worker Program or the SOW program, and we have workers that are coming to Canada under the Agricultural State. So we are going to talk now. The first one is the Seasonal Agricultural Worker Program or the SOW program. In this program, the government allows hire temporary foreign workers when Canadians and permanent residents are not available to do the work. Employers can hire temporary foreign workers for a maximum period of 8 months between January 1st and December 15. So, do we have some workers under the SOW program here for the 8 months program? No. Why? I'm going to mention why. Because this is a program that is only covered or is a treaty between Canada and the Mexican and Caribbean countries. So you are from Philippines, so you are not part of this treaty between Canada and your countries. So this is why. Okay, the employers can offer the workers a minimum of 240 hours of work within a period of 6 weeks or less. The temporary foreign workers must be citizens from Mexico or participating Caribbean countries. This is why I mentioned to you, this is a treaty between Mexico and Canada and the Caribbean countries and Canada. The production must be in specific commodity sectors. The activity must be related to on-farm primary agriculture, and the SOW operates according to the bilateral agreement between Canada and the participant countries. Most of the workers are already ready for leaving from Canada, so they're supposed to leave from Canada in December 15, but because the COVID-19 and other issues, they are leaving early. So I noticed there are some that also are leaving from November, at the beginning of November. So yeah, the SOW workers are not soon. That they are leaving soon, they are not here for a long time, they are leaving even before November. So yeah, we cannot see a lot of workers under the SOW program at this time. We have another one, is this okay, under the Seasonal Agricultural Worker Program, again the SOW program, the employers must arrange and pay for the round-trip transportation of the temporary foreign workers, include transportation from the place when they are living to the place when they are working. So employer must provide day-to-day transportation. That means the employer has to give you transportation from the place when you are working and the place when you are resident, and returning to your place when you are resident. So I know most of the SOW workers are living in the accommodation provided by the employer. So the obligation of the employer is to take a bus and fly the workers from the destination or place and returning to the place that they are living. Also, the employers must ensure that temporary foreign workers have adequate, suitable, and affordable housing, and it may be located maybe in the farm or outside farms. The employer has to provide this accommodation for the workers, depending on how many workers are living in the place. So they have to accommodate the housing for any workers that are coming to Canada. The employers must ensure that all temporary foreign workers registered for provincial territorial health insurance, and also the employers must always ensure that temporary foreign workers are covered from the provincial and territorial workplace safety insurance provider when required by law. The Seasonal Agricultural Workers Program has a standard. It's a contract standard, cannot be modified. It's just the standard of the contract used between Canada and Mexico, and between Canada and the Caribbean countries. The Seasonal Agricultural Worker Program has a one part. That means sometimes there are transfers between parts. So the employer can transfer one worker from one part to another worker, but they cannot do it informally. That means they has to be under the law. So it has to be a legal transfer between employers. Also, this transfer needs the consent of the employer and the parties involved. The employers must apply to get a labor market impact assessment or LMII to be able to hire temporary foreign workers and meet all the employer requirements. So before the workers are coming to Canada, the employer has already applied for a LMII and also do the standard contract and have the standard contract ready for the workers that are coming to Canada. This is the requirements. Now we are going to pass to the agricultural stream. This is another program. Most of you are under this program. The agricultural stream. So employers can hire temporary foreign workers for a maximum period of 2 years when Canadians and permanent residents are not available. So before to get the permission to hire a temporary foreign workers, the employer needs to apply for an LMII and also needs to prepare the place for you. In this program, the activity must be related to on-farm primary agriculture also, and the employer must always to pay for the round-trip transportation. That means provide the transportation the same as a sub program. The employer has to provide a bus or a van or any transportation from the place where you are working to the place where you are residing and return to your place. The employers must provide day-to-day transportation. When I'm talking about the round-trip transportation also, it includes the round trip from your country to Canada. So as soon as you have to leave Canada because your work permit expired or your work permit expired, the employer has to pay for the trip to return you to the country. So this is a round-trip transportation. Coming to Canada and leave Canada to your home country. This is the transportation that I also covered. What else? Employers must provide adequate, suitable, and affordable housing, and the same has to be located maybe inside or maybe outside. So it depends on the accommodation that the employer wants to provide. Employers must always pay for the temporary foreign workers private health insurance. It's similar to the SOAP program. They have to comply the same requirements. The other one, the employers must always to provide and cover the workplace safety insurance, and it is required by law. Employers must apply to get the labor market impact assessment LMII to be able to hire a temporary foreign workers as the same meet the requirements that the government is requiring for the employees. So next one. So work permits. I gave you a little bit introduction about the two programs. Most of the workers really don't know which program belongs. Sometimes when I ask them, oh, are you coming under which program? They say, I don't know. I just signed the contract and that's it. So most of the workers don't know under what program they are coming to Canada. So now you learn now that there are two programs, the SOAP program and the agricultural stream, and there are differences, right? There are very big differences. Just keep in mind why, because at the end of the session, I'm going to ask some questions to you, and I will let know if you know most of the answers, if you learned today something, and we have some door prizes for you. So for those workers that answer a right answer, so you will receive a prize from us. So just keep in mind everything I'm saying. Yeah, so I'm going to continue. There are two types of work permits. One is the employer-specific work permit, or is also called closed work permit. This permit is a specific work permit that allows workers to work according to the conditions of the work permits. So workers can only work for a specific employer for a specific period of time and for a specific occupation and for a specific location. If you notice under your work permit, the brown paper, you see on the bottom some conditions. That conditions always say the same. So you will have to work on the same location, the same activity, for the same employer, and for a specific period of time. It's the time that the immigration the official immigration officer gave to you for the work permits that you are coming to Canada. Workers cannot apply to extend their work permit under the Seasonal Agricultural Worker Program, so if the employer may want to rehire the workers, those workers must go back to their home countries before they can apply for another work permit. Under the agricultural stream that you are under the agricultural stream, so workers cannot apply for an extension. So if workers want to change jobs or employers, they must apply for a new work permit from inside Canada. And to change employers, workers must apply to change the conditions of their work permit. Employers must give workers a new job offer letter, a new LMI number, and a new contract signed by the workers and their future employer. So most of the workers always ask, there is an option, I can change my employer, so I'm not comfortable in this part, can I change it? Sometimes they don't know, but yes, they can change. Why? Because you had a closed work permit that is still valid, right? So if you don't like the place where you are working for any reason, you can consider the option to change employers, apply for a new closed work permit for a different employer, but the requirement is you have to make sure you have a LMII and an offer of employment. If you don't have those, you cannot apply. So make sure. Why? Because sometimes employers make promises and say, yes, I'm going to hire, just come here to work, but you have to make sure that you have the contract on your hand, you sign the contract, it's formal contract, and the worker gives you the LMIN number. If not, you will be lost the previous employment, the previous employer, and you will maybe don't get anything, just you lost everything, the two options. So make sure if you want to apply for a change of employer, you have to have the LMII and the offer of employment from the new employer. Okay? Do you understand that? Okay, that's good. Okay. There is there is another option available recently, is the workers can extend their participation or change their international experience in Canada work permit if they will be working for the same employer at the same location and their job duties won't change. This is a new one. The name is the International Experience Canada program. So this is people with a closed work permit can be eligible for a work permit under this International Experience Canada program only if it's a foreign job who is eligible for the International Experience Canada, has 18 or 35 years old, had a profile between 18 and 35, had a profile in the International Experience Canada, have received an invitation to apply for a work permit, or the International Experience Canada is part of the International Mobile Program, which means employers who hire International Experience Canada participants don't need to complete a labor market impact assessment. This is new. This is a really new program. So I noticed that I don't have any clients or workers under this program because there are some specific requirements that are not easy to get. But most of the workers are not under this program. So, next one. Thank you. Okay. So now we are talking about the open work permit. So I already talked to you about the closed work permit. Most of you are on the closed work permit. Just a few of you has an open work permit. So now I'm going to talk to you about that. So an open work permit allows workers to work for any employer in Canada. So you have an open work permit, you can just stay in this province and go to another employer in Canada. So you can go to, I don't know, to another region or another place As soon as you get the offer, the formal offer and the LMIA, you can use your open work permit and work for any employer in Canada, in any area. So you don't have to just work in a farm or just continue doing the same. No, you can apply for another activity in a different place. As soon as you have an open work permit, you can do it. Okay? Generally, people who obtain an open work permit have some other type of status in Canada. For example, it's most common that the people who has different status, like them from the temporary foreign workers, they had an open work permit as soon as they come to Canada. For example, the protected persons, first stage approval on humanitarian and compassionate grounds, refugee claimants, and permanent residents and citizens. Usually permanent residents that come from for example, the skills, is the name is the, yeah, it's the, for people who is applying to come to Canada as a permanent resident because they have the qualified experience and skills, they can come to Canada and they came here with an open work permit. So these are kind of specific people who has this advantage, different from the other temporary foreign workers. With an open work permit, workers can extend or change the conditions of their work permits. This work permit doesn't confer temporary resident status, it's just a permit. So what that means is an open work permit gives you the option to find an employer in Canada, but they didn't give you the option to be a resident or a permanent resident. It's just an open work permit, it's just a permit. It's just a document. Next. Okay. So in June, on June 4, 2019, the government just launched the open work permit for vulnerable workers program. So the section 207.1 of the IRPR gives RCC the authority to issue an open work permit for temporary foreign workers holding an employer specific work permit who are experiencing abuse or who are at risk of experiencing abuse in the context of their employment. What that means is migrant workers in Canada who are experiencing abuse or who are at risk of abuse in the context of their employment in Canada may be eligible to receive an open work permit that is exempt from the labor market impact assessment LMIA process. So I have some workers that they got the open work permit because they were victims of abuse from the employer. We had one person here. I had the fortune to have one Philippine worker who got very successful in the open work permit application. As I think in June 4, 2019, the government launched the program and we applied with that worker. The second week or the fifth week after the government launched the program, and we got the approval immediately. So we were lucky. I think we were the first person in Canada who got the approval of the open work permit. So yeah, I'm so happy and we were successful. So yeah, it's a good experience and this is a process, very fast process. So we start the application, we provide the supporting documents, and in less than 2 weeks, we always get an answer. Will be an approval or will be a denial, but it's a fast process. So if you try, for example, and you apply for an open work permit and it's denied, so you can apply it again, maybe later, maybe when you have more supporting documents, maybe when you have more proofs, more evidence. So you can apply anytime and you will get an answer in 2 weeks. It's very fast. So this is a very good option. What else? Yeah. This is the one, yeah. Requirements. Okay. For applying for the open work permit, so the temporary foreign worker must be in Canada. The temporary foreign worker must hold a valid employer-specific work permit or have submitted a work permit extension application for the same employer and is currently in Canada on an implied status. This means a temporary foreign worker is precluded from applying if the individual has already lost status but are still within the 90-day restoration period stipulated in Section 182 of the IRPR. And the temporary foreign worker is either experiencing abuse or is at risk of experiencing abuse in the context of the individual employment according to Section 196.2 of the IRPR. What is the employer status? When the employer lost the status because the work permit just expired, usually we apply for an open work permit at least 1 month before expire. Usually it's better if you start before, 3 months or 2 months before expire, but maybe something happened and just please don't apply less than one month after. So we need at least 1 month before expire your work permit to apply for this work permit. When the work permit expires, there is an employer status. What that means is the worker can stay for 90 days in Canada. It's allowed. But you have to restore your status. That means if you are here for 90 days, you are here for a reason. You have to have 90 days but preparing for restoration of your status. Because why? Because if your work permit expired, that means you lost the status, right? But the government gave 90 days to restore the status. It's an implied status. It's an implied time, 90 days for restoring your status. How? You go to find an employer, the employer gives you a LMII, the employer gives you an offer, formal offer of employment, and you can start the process and restore your status. As soon as you get the 2 requirements, you apply for an open work permit, and what you are doing? Restoring your status. So you will have again a worker status in Canada. The temporary foreign workers, when it's experienced abuse, can be directly experiencing the abuse, or maybe indirectly. What does mean indirectly? For example, you notice in your workplace that some co-workers are laughing or are bullying or are harassing another co-worker. So you are not experiencing the abuse, but you see that your friend or your other co-workers are experiencing abuse. What does mean? You will be in risk to be also abused. So it can be directly or it can be indirectly. Okay? Thank you. Okay. To be eligible for applying for an open work permit, workers must be in status. That means they have to have a valid open work permit that require a LMII, or have a valid closed work permit that is exempt of LMII, or be authorized to work without a work permit under the employer status that I mentioned to you. Or for this specific application, there is no fee, it's free. So you can apply online, you don't have to pay anything. So just be careful if there are some people taking advantage of you and offer you to apply for an open work permit and just charge you a money or a fee. No, this is free. Okay? Just make sure you don't have to pay for this. The length of the permit is up to the officer, so a period of 1 year is suggested. Usually, as when you apply for an open work permit, the immigration officer gives you 1 year open work permit.
Excuse me.
Yep.
I have a question.
Yes.
Just in case the 1 year period it's already expired, so are you going to? Can we apply for another a year, or
Okay.
can we renew it?
No. The open work permit, under the open work permit for vulnerable workers, cannot be extended, cannot be renewed. As soon as the condition, the vulnerability expire, you don't have another option to apply for a new one or for extended, so you have to come back to your country and apply again for a closed work permit. Okay, what kind of abuse? Next. What kind of abuse can you experience in your workplace? Abuse can be physical abuse, including assault and forcible confinement. Will be maybe sexual abuse, including sexual contact without consent. Maybe psychological abuse, including threats and intimidation. Or maybe financial abuse, including fraud and extortion. Maybe not paying you the wages owed to you. Maybe stealing or taking a worker's money, salary, or checks, or coercing them into giving them up. So this is kinds of what abuse that you experience. I'm going to tell you some examples of what is abuse. So sometimes you hear, oh, physical abuse, sexual abuse, psychological abuse, but you don't know what kind of conduct or behavior means abuse. Okay, I'm going to show you some examples of abuse or risk of abuse. So the employer, recruiter, or both have coerced the migrant worker into paying job placement and recruitment fees. So the employer say, okay, I bring you to Canada, you came here, you have to pay me for your flight. You have to pay me for the trip from your country to here. You have to give me your passport, you have to pay me for a long time, just give me installments, give me a fee every month, so I'm going to charge you because I bring you. So this is not allowed. So the employers and the recruiters cannot ask for the worker to return any money or to pay any flight or any ticket to come to Canada. Another form of abuse is the employer on several occasions doesn't pay the wages owed to the migrant worker. So, for example, the employer is working, has a salary, has discounts, the normal discounts, the legal discounts, but also the employer is taking the money and saying, no, I'm not going to pay you because you didn't work the hours that you promised. I'm not going to pay you because we are changing the method of the activity. For example, I'm not going to pay you per hour. I'm going to pay you just per the activity you are doing. I'm going to change the activity, so I'm not going to pay you the salary. Or just take the money or take the check and they didn't give you the money. This is abuse. Another way of abuse, the migrant worker on several occasions is harassed. For example, unwanted physical or verbal behavior that is offending or humiliating by a co-worker in the workplace. If the employer treats you very bad, or calling you names, or treating you, or humiliated you in any way, for example, say, you are from that country, you are very lazy, you don't do the work properly. So if the employer says that, if the employer humiliates you, if you feel bad when the employer is treating you in that way, this is an abuse for sure. This is a harassment. Okay. For example, the migrant worker is threatened by the employer if they complain about their work conditions. For example, if the employee decides to know information about employment rights or about immigration rights, and the employer say, no, you cannot go in, not let you go to the meeting, don't go to the presentation, you have to stay. Or if, for example, the worker call an organization or a legal clinic or something like that, and the employer coerces you and doesn't let you to call or doesn't let you to go to the place, to the community office or to the legal agency, whatever, this is an abuse. This is a way of abuse or risking abuse. So you have rights, and your rights are to know your rights, understand and exercise your rights in Canada, and the employers cannot prevent you to do that. Forcing or pressuring the migrant worker to perform work that contravenes the conditions of the work permit. For example, working for a different employer than stated on the permit or performing different job duties. This is a form of coerced engagement in illegal activity and may be accompanied by an enabled further threats, intimidation, and abuse. What that means is, I mentioned to you under the bottom of your work permits, there are some conditions. The conditions say you have to work here, for this time, in this location, in this activity. And the employer say, no, I need you for a different place that I have. So you are not going to work in this part, you are going to work for maybe cleaning a place, do cleaning services. I say, why? I came to Canada as a farm worker doing agricultural activities in the primary sector, so why I have to clean a place? This is abuse. Okay? They cannot change the work conditions that are strictly specified in your work permit. Okay. What else is abuse? Abuse is insulting, intimidating, humiliating, harassing, threatening, including with respect to immigration status or deportation, name-calling you, jeering, blaming, shaming, ridiculing, disrespecting, or criticizing a worker. This is not allowed. That means the employer cannot, even the employers and the co-workers. Employers means no employers has to do that, no supervisors have to do that, no co-workers, nobody has to humiliate you, threaten you, or be unrespectful, because you are coming here to work as a dignity humans. If you are here, it's because you have the skills, knowledge, experience, and you are qualified to do the work without any harassment or discrimination. Okay? The migrant worker may not be directly experience abuse, but may be in situations where the co-workers are being abused by their employer, putting them at risk of experience of an abuse behavior. I just talked about this. It can be directly or can be indirectly. Next one, please. Okay, what happened during COVID-19? There are more forms of abuse in the context of COVID-19 related to working and living conditions of the migrant workers. So what happened is, maybe not now, we cannot experience the cases that we had at the beginning of the pandemic, because now the employers know what they have to do. The employers have been educated about how to deal with COVID-19 now. But at the beginning of the pandemic, the first 2 months, I think, we received a lot of complaints of migrant workers because they were abused under the COVID-19 pandemic. So what kind of abuse? The employer doesn't provide wages, always in the mandatory quarantine or isolation period upon entry to Canada. The migrant worker was forced or pressured to perform work that violates the conditions of a mandatory quarantine or isolation period. Or the worker is forced to work when showing symptoms of COVID-19, or forced to work with co-workers who should be in quarantine or who are symptomatic. So I noticed some employers mixed the workers. So put the workers, healthy workers, with the COVID-19 positive of COVID workers. So they mixed the workers. This is not allowed. This is a way of abuse. So no, it's not. The migrant worker is prevented from seeking medical assistance. For example, at the beginning of the pandemic, I noticed that most of the employers were afraid. What is happening in my farm? Oh my God, all the workers are positive for COVID. So what they do is they force the workers to stay into the place and prevent them to look for medical assistance. They say, no, you have to stay in the farm, you cannot go anywhere. If you need something, we can bring the food or something for you, but you cannot go in and find a doctor, or even you cannot go to the pharmacy. We have that cases at the beginning of the pandemic, a lot of cases really. The worker is not provided with adequate tools and working conditions to implement public health and social distancing protocols. That means, for example, at the beginning of the pandemic, the workers didn't provide sanitizer for the work, the employer didn't provide sanitizer for the workers, or didn't provide a mask, or they never cleaned the superficies of the tables or doors or anything, so they didn't clean. Even they didn't give the workers the tools to do it. So this is an abuse. Reprisals. Reprisals actions against a worker for taking sick leave or refusing to work in unsafe working conditions. The employer doesn't provide appropriate and adequate accommodations for quarantine, self-isolation, or the prevention of a virus spread. Failing to provide workers with cleaning products to prevent the spread in shared accommodations. So it's the same as I mentioned. So if you live together in one room, 5 workers or 7 workers, I don't know how many, and you know the beds are together, so help with help. So there is no distance. So where are the 2 meters distance required? So you, the employers at the beginning, maybe there are some employers that still are violating the health and the health protections and health measures for COVID-19, maybe. But at the beginning we had a lot of cases, they didn't maintain the properly adequate measures for COVID-19 in the bedrooms and in the lunch time, you know, in the restaurant. I don't know if you had a restaurant in your places or you had a place for lunch, so the workers, even just the workers just eat together, or maybe the workers just go to the 4 rows and pick up the fruits and pick up everything just with a 1 centimeter of distance, just together. So, what measures? The measures are not compliant for the employers in this kind of examples. For example, the employer prevents the worker from obtaining essential items during the quarantine or isolation period. For example, groceries, medication as mentioned before, or fails to provide adequate alternate arrangements, for example, assisting with pickup or delivery. For example, I know at the beginning of the pandemic, the employers prevent the workers to get food and say, no, you cannot go for shopping this Sunday, this weekend. I can't do it for you. So they delegate a supervisor or somebody just to buy the groceries. And if they don't the groceries, sometimes the workers say, okay, I'm going to order food, I'm going to order deliveries for me. I want food. And the employer say, no, you cannot. Sorry, nobody can come to the farm. Anybody can be positive of COVID, nobody can come to the farm. So the employer prevents the workers to get the food or any delivery or any groceries or any medications. These are forms of abuse. Okay, so now you already know what kind of abuses are in the workplace, so you can identify if you are experiencing abuse in your workplace or the co-workers that you are working and have experienced abuse or are at risk of experiencing abuse. Now we are going to talk about how to apply. How to apply for an open work permit for vulnerable workers. Workers can apply directly to Immigration, Refugees and Citizen Canada, IRCC, for an open work permit for vulnerable workers by filling out an application online. Workers have to include in their online application supporting evidence of the abuse if applicable. What kind of evidence? You have to prove that really the risk of abuse is existing. For example, you can submit a description of the abuse or risk of abuse faced by the migrant worker. What does mean is the description? What is the description? The description is, for example, you can just put on a letter, put in a paper, the facts that you experience. You can say, on June 20, 2021, the employer hit me, the employer treated me, the employer humiliated me, or the co-workers just were very unrespectful with me. You have to put everything in a letter, preferably in a chronological order, with dates, where, when, and who did that behavior to you. So everything has to be in a letter. Just remember the dates, remember what happened, who was around, who saw that, oh, I was with John. John was next to me. So everything has to put in a letter. Maybe by typing, maybe handwriting. Put your signature, the day, and most of the facts. I mean, better have more facts than less. Put everything you remember in a letter. Also, a statement is the same. A statement or a letter or report from an abuse support organization. What does mean is you can provide your own letter, individual letter, but you also can file a statement or report that other organization has about your case. What does mean is, for example, at the workplace, somebody hit you. The supervisor say, "Oh, you are lazy. You are not working properly," and push you, hit you, and you just go to the wall and you got an injury or something like that. And you have to go to the doctor, and the doctor say, "Oh my God, yeah, we need to, maybe you got a fracture, or maybe you need something to helping you go to the hospital or something like that. So you need time to recover or something like that." The report of the doctor is going to help you with the application because you was hired by the employer, and the employer hit you, and the employer caused an injury to you. So this is an injury caused by the employer in the workplace. So it's helping you just have the letter, the medical report of the doctor, or any organization that helped you at that time. A copy of an official complaint form filed with an enforcement agency. For example, there are many enforcement agencies and organizations in Canada, so you can take any of the report or any of the application from there as a proof. For example, I have some cases when the employer cause an injury, or co-workers cause an injury in the worker, and the worker went to the doctor, and the worker called the police, and the police came immediately, and the police filed a report and said, "Okay, I had a report, I called the police came, the police just put everything on writing and filed a report. I had a report." So use that report, ask for that report to the police station, and that is a proof of it's an evidence of your abuse and your physical situation at that time. Also, the Canada Border Services Agency is another enforcement agency, or maybe a report from the other organization, so it works. Or maybe just you contact the tip line, call the tip line or the government of Canada tip line and report the abuse. It counts as a report. You can use that as an evidence. Also, you have to file a copy of an official complaint completed by the migrant worker and submitted to a provincial enforcement agency, such as an employment standards branch, human rights tribunal, or the police. For me, my experience, the most important evidence in this application is to submit the complaint that you previously did to the Human Rights Tribunal because you was victim of abuse or harassment, or before the Ministry of Labor because you was victim of the employer failed to pay you the wages, the legal benefits that you have to receive or something like that, or also the police report. So it's mandatory. Well, it's not mandatory, but it's better. It's mandatory. It's a requirement. You have to file a complaint before to apply for an open work permit. So what you have to do first is notice that you are experiencing abuse, or you are in a risk of experiencing abuse. Complain to an enforcement agency, or complain to any of the organizations that I mentioned to you, enforcement agency. Keep the proof of the acknowledgement of the organization and attach the complaint as a proof, as an evidence that you already complained. Okay, this is the most important thing. Your complaint. Okay. Supporting and additional materials. So, for example, you can attach a victim impact statement, or you can attach hard copies of the email messages, photos showing injuries or working conditions, or witness testimonies. It's not easy, I know, but you have to find a way to take pictures. Please do it in a properly way, don't be imprudent. I know some of you maybe can be afraid if the employer just catches you taking pictures or something like that. I know it's a risk, but if you want to show that you are experiencing abuse, you have to have evidence. And evidence means photos, emails, text messages, WhatsApp pictures, and witnesses, your other co-workers. Oh, somebody saw how the supervisor was treating me. So you can say, yeah, Jason saw everything. Jason was there at that time when the supervisor hit me, or when I was discriminated, when everybody just laughing about me. You can have that witness testimony on paper, maybe in an affidavit. Usually it's better to have an affidavit signed by a commissioner or a notary, and just present as an evidence. So it's very important to have evidence. If you cannot prove your application properly, your application has not merit. If it doesn't have merit, you will be denied. You will be received an unsuccessful decision. So always prove, always. Never think that it's not enough. No, always has to have more evidence than you can. Whatever you have, put it in the application. Just attach it as supporting documents. It's better to have more and more evidence and no less. Okay. Okay. This is a list of the resources where you can go to get some advice, or somebody who can help you to fill out an application for an open work permit for vulnerable workers. You can contact my clinic, the Windsor Essex Bilingual Legal Clinic. These are the phone numbers. You also will see the flyer later, and all the information is there. You can contact Legal Assistance on Windsor, Community Legal Line. Any of the organizations here can help you to fill out an application. You don't need a lawyer to apply for an open work permit for vulnerable workers, but you can just get assistance. Maybe somebody can help you to fill out the forms, or just can help you to understand what the application is asking, or maybe somebody can assist in you to gather all the supporting documents, or maybe can help you with the affidavit. So you can contact us, you can contact any organization, and you also can contact KAIROS. KAIROS also has some people that is helping the workers for the application for vulnerable workers. Next one. Okay, thank you so much. Maramin Samalatpo. Thank you so much. I try to pronounce well, but I don't know how. So thank you so much, everybody. Thanks you for coming to this information session. If you have questions, you can ask questions now. Oh, I want to remember something to you. You can ask questions, but please try to ask general questions. Why? Because if you are talking about your particular situation, we need to have an interview, or I need to gather your information and to know more details about the case in a privacy and confidentiality manner. So today, if you ask questions about your specific situation, I cannot answer to you today. I cannot provide legal advice. This is just an information session. But if you need legal advice, you can contact our office, you can contact me, and I can have a confidential meeting with each one, or whatever person who wants to reach me, and we can start a process, or we can start an application. So thank you so much. I'm waiting for questions. Don't be shy.
General question.
Ask questions, don't be shy. This is an opportunity to talk about this amazing open work permit for vulnerable workers. Yeah.
Hi. I have a question. So, one of the things that sometimes holds back a worker from, let's say, reporting or applying for an open work permit due to vulnerable reasons, is because they're afraid of retaliation. Let's say, I applied and then all of a sudden it gets denied. My fear is my employer might get back to me, or at the same time, there's so many ways that the employer sometimes will get back to you, like, let's say they will not renew your contract, or all of a sudden they will send you home. What sort of protection would the workers have, considering that the vulnerability of their case and the risk of retaliation?
Okay. Yeah. I have many questions in the past asking the same. The employer, that means you are under a contract. The employer is the person who controls in any way your work and your stay here in Canada. So you have rights, you can access to the rights, you can exercise your rights, but you are protected in many ways. So most of the workers are afraid of reprisals, you're right. Usually the cases that I already have are from workers that decide to quit the jobs because they were abused. So they cannot tolerate more abuses. So most of the cases that I have are from workers that decide to leave, decide to find another job, or just to go because it's impossible to live in that situation. Yeah, there is a risk for sure. The employers usually, not most of them, but usually employers take reprisals from the workers. This is not allowed. The workers are protected under the government of Canada. You can apply, you can file an anonymous, it's like an application, but it's not an application, it's just a tip line, it's a call. You can call anonymously, there is a tip line, and you can report the abuse. So you don't have to say your name, you only have to say which part or which place is that, and the employer has to, obviously, has to get some penalty for that, right? So the government created tip line. I'm going to give you the phone number. I think it's in one of the papers that I'm going to give you later. There is the number there. You can call anytime if you are experiencing an abuse or the employer is violating the temporary foreign workers program. So don't be afraid of that. It's anonymous. You can contact the tip line and inform. So you are protected. Your rights are protected. You also are protected by the other acts that are protecting the Foreign Nationals Act, that is protecting the temporary foreign workers. There are a lot of protections. Maybe you can be afraid of the consequence if you go to a legal clinic or to a community organization and apply. Usually, when a worker applies, the employer doesn't know. Why? Because it's an online application. So the worker can apply online, can just file, submit the supporting documents, attach it with the open work permit, and just wait the decision. 1 week, 2 weeks, just get the decision, you get an open work permit, and you say, bye. No reason to stay. Right? Why? I decide to go. That's it. So you can go anytime. You got approval on your open work permit for vulnerable workers. If, for example, you ask, I have some questions about it. For example, I mentioned to you the most important evidence to get successful or at least to get merit to apply is the complaint. You have to attach the complaint to an enforcement agency in order to apply for an open work permit for vulnerable workers, right? So the Human Rights Tribunal or the Employment, the Ministry of Labor or the police record and all the enforcement agencies are not going to contact the employer, not immediately. It takes time. So the organization, for example, the Human Rights Tribunal, they gave the application and it takes time, 1 year, maybe more than 1 year, in order to access to the employer. To get the employer, that means a hearing or something, or a settlement or something, it takes time. It takes time for the hearing. It's a long process. So probably 1 year later, you got the open work permit and you don't have to see the employer anymore. So don't worry. I know you are afraid of, but it's really easy to exercise your rights. Just contact a legal clinic if you have questions, or if you need support to apply, contact our clinic or any other organization that I mentioned to you. Apply online. The employer doesn't know that you are applying, so don't feel afraid. And if you find enough evidence, if your application has merit, you will be successful and you can just go. This is the process. So I understand about you, and I really want to mention the tip line is helping a lot. The government of Canada directly, they created the tip line. The tip line for temporary foreign workers who can apply and can report employers that are abusing of the workers in Canada. So you have the information into the kits that we are going to provide you. So yeah, you have everything there. Now we are going to finish this session. Thank you so much for participating in this session. I hope. Oh, there's another question. Sure.
The question is that if it's the supervisor or your superior asks you to do a job that's not in your job description, is it an abuse?
Yes, it's a way of abuse. Yeah. The employer cannot change your work conditions that are specified on the bottom of your work permit, close work permit. If that is happening, it's an abuse.
Is it that you have to experience abuse to apply for your work permit?
Sorry, I can't hear you from here.
Is it that do you have to experience the abuse from your employee to apply for a work permit? Open permit?
Yes, yeah. That means you are asking if there is an abuse.
If you don't experience that one?
If you don't experience any abuse?
Yeah.
No. You have to experience abuse. That means you have to be discriminated, or you have to be harassed, or you have to be in any risk of abuse. So it's easy to identify the ways, the forms of abuse. You know, when you don't feel comfortable with the words that the employer is using with you, when the employer say, you are lazy, just work. Oh, all Mexicans, Salvadorians, or all Philippines are lazy. You always work very bad, or something like that. This is bad. This is humiliating you. This is not good. This is just discriminating you because of your nationality. So any discrimination, any harassment is a way of abuse. Maybe the most simple thing will be abuse. Yeah, so it's physical, it's psychological, it's sexual maybe, or any way of abuse can be abused and will be a good reason to apply for an open work permit. Yeah, thank you for your question. Yeah.
If your supervisor is treating you, if you have not passed or you are slow, treating you send home and bill for 2 weeks, 2 days, it's abuse.
Yeah. There is abuse when your employer say to you, our participant here, say, if the employer, for example, say, I'm going to send you to your home because you are lazy, you are not doing the work properly, and I'm going to call, sometimes the employer say, I'm going to contact the Canada Borders Agency and to report you as no status or something like that. I'm going to deport you. I'm going to call for deportation. That behavior from the employer is not right. It's illegal. Nobody in Canada,
Even my co-worker,
even your coworker, nobody, no your employer, no your friend, no any person can treating you saying I'm going to call the border agency and ask for your deportation. If that happens, you have to call the tip line because it's not allowed. It's a behavior that is not allowed in Canada from employers or any other person. No your coworker, no your neighbor, nobody can threaten you and saying I'm going to contact the border or the government to say that you are here and you don't have status or something like that. No, this is not allowed. It's an abuse. Yeah?
Good evening. Thank you for the information. Alright, so to be clear, right? So we have a permit for 2 years. And we're experiencing abuse. And we would like to apply for the open work permit. From what I heard, the time frame on the work permit, the open work permit is a year, basically. A year, right? And after that year, you'd have to go back to your country in order to get another closed permit to come back here. Alright. Now, you're experiencing the abuse, right? But if you continue working and they decide to renew your contract, it can be done from here. So what are the benefits of the open work permit?
There are benefits. The open work permit allows the worker to work for any employer in Canada. So you don't have to work as a farmer or knowing the same city or in the same region, not for the same employer. So you can just find any employer that offers you unemployment. So you can, for example, work in construction, or you can work in any industry, activity, occupation that the government of Canada has for temporary foreign workers. You can apply. You can just work here, or just travel to Toronto, or just go to another place, or work in a different industry, in a different activity. This is the benefit of the open work permit. What are the benefits? Other benefits, for example, you start getting relationships with other employers. So maybe you can get a good relationship with the employer, and the employer can offer you a full-time job, as happened with my friend
Okay,
here.
so in that case, then you don't have to go back to your country after the contract, or you still have to go back even though they offer you that job.
Yeah. So as soon as the closed work permit expires, you have to come back, but you have the 90 days employer status. Yeah. So if the employer, for example, say I'm going to offer a full-time job, and I want to have you as apply for this position that is available in the company. I'm not talking about farms. I'm not talking about, for example, a company, and they say I want to give you a probation time, and if you qualify and if you pass your probation, you can work with me. What that means is you had a new offer of employment and a new, no, you don't need an LMII because it's a company that is offering a full-time job. So if you get before your open work permit expires and you can apply, that's fine. But if you don't find any job, full-time job, if you don't get an offer, you have to come back to your country. So I doesn't want to say that you are extending. No, you are not extending. You are not noticing. If you want to apply, you need a new open work permit from your country, or depends on the circumstances, just apply from here. So this is the same that happened to my friend Ryan has been our client for a long time, and Ryan had the same situation. He experienced abuse. We applied for an open work permit. He got an open work permit. After that, he was very lucky, and he got an offer from a company. The company offered him a full-time job, and finally, Ryan, during the new permanent resident pathway for temporary foreign workers, applied for his permanent residence. Now we are waiting for the decision. So I know Ryan is one of the lucky person in the world because it's just, I don't know, the closed work permit and the open work permit for vulnerable workers program is not a pathway to get any permanent residency. It's not a pathway, it's just a permit. But Ryan was very lucky, and Ryan got a full-time job in Canada. He got an LMII, he got an employment contract, and he passed the probation. He got successfully the probation, and now he is hired full-time, and he applied for his permanent residence. Is very lucky. No, most of the workers can do that, or the circumstances. The pathway that I to mention to you, the pathway that started, I don't remember, many months ago and finished very soon. It was just for a few applicants that had the opportunity to apply and meet the requirements. So, yeah, Ryan was at the perfect time, the perfect time to get an open work permit, perfect time to get a full-time job, and perfect time to get the pathway. So he is the lucky guy. But most of the workers are not. Unfortunately, they have to come back to their countries and apply again for a closed work permit. Yeah. More questions? Okay.
If we don't have pictures or videos of an abuse, is the testimonies of all the witnesses enough to be as an evidence?
Okay, thanks for your question. He's asking if he doesn't have any pictures or only have the testimonies of the other co-workers as a witnesses, it is enough for an application. So my answer is depends of the immigration officer who reviewed your application. So if there is not merit, if there is not enough evidence for the immigration officer, you will have a denial application for sure. Try to get most of the evidence and justify the abuse. So depends on the immigration officer decision. They have the discretionality to decide on the merits of your application. But always, if you are applying for any application, you know if it's enough. Yeah, you say, oh no, my application is very poor. I don't have anything. So you will be expecting a denial, right? So, but if you say, no, I have these, I have witnesses, I have 3 witnesses, they want to support me, that's good. I had an affidavit, I have some emails that they never replies to me. So that if they refuse to give an answer, this is an abuse too. They have to answer to you. So if you have text messages by WhatsApp, if you have something like that, you have a video, when the employer is just threatened by the employees. So it counts. Any evidence counts. It depends on the discretion of the immigration officer to design your application. Yep.
The employer and the supervisor, they don't want you to take any phone in the form. So it's only the evidence that the co-worker you have.
Yeah, this is why I mentioned to you, just be careful, be prudent if you have to take pictures, right? So if you notice the abuse and they don't allow to take cell phones in the workplace, you have to find a way. You have to find a way to record or to take pictures, or I don't know. I cannot explain you how to do it, but in the cases that I already have and we apply, we have proof. We have WhatsApp comments, we have WhatsApp text messages, we have pictures, or we have witnesses. So anything you have counts. So yeah, just get them more evidence and you will be get successful.
What if the contract not following the employer? We have a contract in the Philippines, something 6 days in a week, and then one day off. The employer not comply the contract. We work 7 days in a week. That's it.
It that happen if, for example, the employer doesn't comply the contract that you signed when you came to Canada. The employer is in violation of the Employment Standards Act. So there is another area of law. You have to look for assistance from a community organization or a legal clinic because it's an employment matter. It's an issue about your employment. This is a different area of law, and you can get assistance how to file a complaint because of that. Yeah, obviously you need evidence. Obviously you need a confidential meeting with the person who is going to help you. You need to find maybe a retainer. Any situation is just decided according to your specific situation. Your situation is different to the other worker, your experience is different to the other worker, so any case has to be assessed individually in order to provide legal advice or legal representation or assistance. Yeah. Okay, yeah?
It's not clear for us about the having a rest day after the vaccination. After vaccination, is it a violation to an employer if they don't let us having a rest after our vaccination?
When you sign your contract, all the contracts, the employment contracts in Canada, has to be legally, has to follow the Employment Standards Act requirements, has to be according to the legal employment law. If your employer didn't follow that, if they don't let you to rest, or and you didn't notice, your contract probably, when you sign your contract, the contract didn't say that, right? The contract says you have to work 43 hours, Monday to Friday. I don't know, but what I want to say is what I mentioned to you, the same, any person has a different situation, particular case. Any person has a different case. So for example, your case is different to your friend. So you need to see your contract, and seeing your contract, what are the clauses and what are the conditions in your contract. If the employer didn't follow the contract, as you mentioned, he didn't follow what the clauses are in the contract, obviously it's in violation of the Employment Standards Act, and it's in violation of, because you sign a contract under that conditions. Yeah.
Can you consider violation if we are working to another farm? If we, like for example, my employers own 3 farms. So if we have not no work in my farm, then they are send us to the another farm and work for the farm. That is a violation.
In your work permit, if you see the button of your work permits, closed work permits, you can see the conditions to work in Canada. And you will find in your work permit the farm or the place when you have to work. If the other places are not belong to the employer or the company or the farm you are working, obviously is in violation of the work permit conditions. But in the, for example, the X farm, well, I mean, Apple's farm, for example, for mention something, Apple's farm has some other Apple's farms in Kisby, Leamington, Brantford. If they have some places that belong to the same company, that's fine. But it doesn't belong to it don't belong, if the places don't belong to the company, so this is a violation of your work contract because he's using you to do activities that are not into your close work permit.
Even if it is owned by the same employer or
You have to work under the same employer.
but it is owned, but it is owned by same employer, but it is a different name of the farm.
It depends on the company. So I cannot answer in an accurate way because I don't know which farm is, which company is. We don't know if it's registered or not. We don't know if they have more other additional, another extensions of companies under the same employer. I cannot answer that question. Maybe you can contact me and we can figure out if they are the same attributes or attachments of companies to the employer. So we need to review your specific situation.
Well, for me, that is not a question. It's pertaining to the last question. I would just share a little experience. I would say I don't think that would be a breach of contract. But we go through the same situation. Like my boss, he owns his farm, but he has share with another farm. So he is still my boss. So when no work is at my farm, he is still the one responsible for that farm at another location. So I don't think that would be a breach, because at the end of the week, the same hours, that's my boss still gonna sign my check for all of those hours that I work. So.
Yeah, it depends. Yeah, it depends on any situation in particular. Yeah, so if the other places belongs to the employer, so that's fine, because if you are working in the same area in the same company or the same company in different places, that's fine. But if it is not the same employer, obviously there is a violation of your conditions of your close work permit. Okay, I think it's enough. I hope you had a very good time. Enjoy the food, enjoy the presents. We are going to say thank you, Government of Canada. Thank you, Kairos. Thank you, International Workers, for these presentations and for providing you this amazing time here so you can eat. I know most of the workers here are Philippines, so enjoy the pancit, enjoy the other food, enjoy your presents. The Government of Canada and Kairos and Care for International Workers prepare some kits with many nice items and yeah, personal items for your care and clothing and everything for you. So enjoy the presents. Thank you so much for participating in this session. I hope to see you in other sessions too, and thank you so much.